Hi, everyone. A lot of good questions about this particular discussion, starting the complaint and other pleadings too. So I thought I'd go person to person and try and give you a quick answer to those. Are there preliminary objections in federal court? No, there are not. In federal court, generally they'll use a few different types of motions. A motion to dismiss is the same as a demurrer. Demurrers, if you remember, say, accept everything that the plaintiff says, they still can't win. And that's one thing that the federal courts do, but they call it a motion to dismiss. Additionally, they will use a motion for a more particular statement if they think something is vague. They'll use a motion to strike if they think something is improper. And that's about it. But that's the story with respect to federal court. Why doesn't a complaint have a proposed order? Cerberina asks. A complaint isn't going to be resolved with an order from the court. Two things are. A motion would end up with an order. In other words, you're filing a motion asking the court for help, and then with the proposed order, you're sending along what you want the judge to sign. This helps the judge, and it also helps the other side. When I've been practicing law, if somebody files a motion and I read what they're looking for, and it doesn't really faze us, I just don't need to worry about the motion. We can let it go through. But so with a complaint, you're at the very beginning of the case and we don't know how it's going to resolve, so it's a little bit premature for a proposed order. Nick asks, are pleadings ever used as a means to obtain discovery, or would it be informal to try and do so? Pleadings don't generally ask for discovery. We will get into discovery, and there are different types of devices that discovery uses to get the discovery, so we'll get to that. Somebody wants me to submit a sample of a jury demand and jury demand. I'll get that too. If you have a complaint, at what point does it make sense to have representation by an attorney? I think from the beginning, the attorney is going to set forth your claims and presumably get them all out there. So if you don't use an attorney and you don't make all the proper claims, if you get the attorney in much later, you may not be able to add them. That is, you'll have waived certain claims. So I was asked, when should you get an attorney? If you can afford it, get an attorney at the very earliest. If someone files a complaint and then decides there's an additional party at fault, would you have to file a new complaint, or can it be amended? It can be amended, and that's how you do it. It would be amended. They don't use preliminary objections in federal court because federal court thinks that that's a sort of an outmoded style. Preliminary objections are in Pennsylvania, which is a fact pleading jurisdiction. The federal courts are a notice pleading jurisdiction. So in federal court, all they want the complaint to do, or any of the pleadings, is give you general notice of what's going on. In Pennsylvania courts, they want the exact facts of each item. So that's really the difference. I think I'll take a break here and start a second one in a moment.